next debate that I wish to touch upon that they raised was, and this is an important proposition, the appropriateness of the declaratory orders. Now, there was talk, and I go on a very high level because it's all fascinating, but irrelevant to the DA's case, and that's what I said at the start. There's Naptosa, there's this question of, as I recall, provision dealing with declaratory orders under the Supreme Court Act, now the Superior Courts Act, and the court has a discretion. Your lordships and your ladyship heard the debate. Irrelevant. That's not what this case is about. This case is about a pleaded constitutional declarator. If one looks at paragraph 1, it says the policy is inconsistent with the Constitution and invalid. That is classically no more, no less than a 172(1)(a) declaration. And to talk about Section 21 of the Superior Courts Act or the Supreme Court Act and discretion has no place in this constitutional case. It's just not available to any party to make that submission. And when we go to the appropriateness of the declaratory orders, I have two broad submissions. The one is, as long ago as Darwood was the first case that the Constitutional Court decided that where the court considers law or conduct, and it comes to the conclusion that this law or conduct is inconsistent with the Constitution, it has no discretion. It must declare, bearing in mind the words of 172(1)(a). Must declare. And what the court always has a discretion in every single case that comes before it in the constitutional setting is to issue an order which is just and equitable under 172(1)(b). So the court may, if it's so invited, make any order that's just and equitable to ameliorate the chaos that could come. And we've heard, our learned friend for the ANC, our learned friend for the minister says, well, if you give this declarative, there'll be chaos. All these cases will come out of the woodwork. All of these decisions will be set aside, or potentially set aside. And I invite the court, not for me to do, it was for them to do, but I invite the court to deal with that by making an order that the court finds is just and equitable to ameliorate the potential that our learned friends talk of. All these 85 cases of cadre deployment which are suddenly up for grabs. Make an order that the declaration is only prospective. The DA will be happy with that. The DA is not here to seek chaos. But every Director General that's ever been appointed deployment through a unlawful deployment policy to be set aside, or all the decisions, we're not here. We're here to stop what's happening in the future. So that I leave to the court. Our learned colleagues, properly so speaking, should have said, well, if you are minded to make this declaration, only make it prospective. It happens every single day. And I ask the question, the appropriateness of the declaratory orders. They say it's in the air. It's abstract. It's got no direct impact because it's not about a particular deployment decision. The Constitutional Court has dealt with that submission and rejected it in rail commuters. In rail commuters, the Constitutional Court said in 70, I think it's 70, sorry, my Lord, I'll give the reference. It said that it was about the trains in Cape Town. I think somebody fell off, got killed. And the question is, they came to court to say that the rail commuter organization, it's Rail Commuters versus Transnet 2006, 2 SA Law Reports, SA 359 Constitutional Court, and they explained the importance of declaratory orders in 107. A declaratory order is a flexible remedy which can assist in clarifying legal and constitutional obligations in a manner which promotes the protection and enforcement of our Constitution and its values. That's what the Constitution says. Our learned friends, for the President, the government, and the ANC, says, don't make declaratives in the air. The Constitutional Court has said, make declaratives for that purpose. And it goes on. Declaratory orders, of course, may be accompanied by other forms of relief, such as mandatory or prohibitory orders, but they may also stand on their own. It's what we ask for. It's what the Constitutional Court sanctioned in 2006. We've heard huge arguments about this, in conflict with what the Constitutional Court has said about declaratory orders. And it goes on. In considering whether it is desirable to order mandatory or prohibitory relief in addition to the declaratory, the court will consider all relevant circumstances. It should also be borne in mind that, this is 108, that declaratory relief is of a particular value in a constitutional democracy which enables courts to declare the law on the one hand, but leave to the other arms of government, the executive and the legislature, the decision how best to implement, etc. Not entirely relevant, but the principle at stake here. And let me say what's interesting. In our replying affidavit, and I'll come to the next chapter of these different headings, is pleadings. There was a complaint about Swissborough, that we haven't complied with Swissborough. I don't know if your lordship, ladyship, remembers Swissborough. Because I remember it because I was here in 1997 arguing Swissborough in this very court. And it's a long judgment. It's about discovery. And it sets out as the leading case for many, many years since 1997, how pleadings are to be dealt with. And one of the important aspects, I'm going to make 2 points on the pleading point. One of the important aspects of Swissborough is that a party is at large to make any submissions on the law which are borne out by the pleadings. And these pleadings, the affidavits by the ANC, the affidavits by the President and the government, and the affidavit by the Minister, point in one direction, that the law demands that the orders that we seek be given, as a matter of pleading. But it goes worse than that. Because I'm going to refer to a case in a series of cases called, well, 2 cases, Pretoria Portland Cement. It's the judgment of Scuts JA versus Pretoria Portland Cement versus Competition Commission, where I think it's in paragraph 63. Justice Scuts makes the point that if in the replying affidavit an allegation is made, in that case the allegation was made in the replying affidavit that a person that I mentioned yesterday, Advocate Menzi Similani, in the question of the President appointing in the NDPP, that in that case he was I think he was the CEO of the Competition Commission. And the Competition Commission went and investigated the Pretoria Portland Cement, and he turned up at the place and he called the press, and there was a complaint about this, and they said that he was lying on affidavit in the replying affidavit. So in the replying affidavit, for the first time, there was a suggestion that Mr. Similani was lying in what he said about the visit to PPC. And what Scuts JA said was, where there is an imputation of dishonesty, even in the replying affidavit, and I'll give the reference is 2003, volume 2, SA 385, SCA, Scuts JA at 63 says, the last sentence, now it is true that Similani had no right or duty to answer this allegation, was an allegation of dishonesty, made in reply, but I would have expected him to offer to do so if Gomerson's imputation, that's in the reply, of dishonesty were false. And we also asked that the court have reference to this proposition in Tantush, it's a judgment of this court, versus Refugee Appeal Board and others, 2008, volume 1, SA 232 at 70, where Murphy J makes the same proposition. I think it's 17, there's another paragraph, which I think I'm reading paragraph here, it's not just that paragraph, there's another paragraph in Tantush, I think my junior's got the wrong paragraph, I think it might. Anyway, the proposition is this. Our learned friends for the ANC say, and I think for the President as well, no, it was just the ANC. Well, the DA's complaint against the President that he'd misled the Commission was only made for the first time in reply. And the whole question of, we were invited to make a supplementary affidavit when the Zondo Commission report came out, but we chose not to, and therefore there's a pleading complaint. Firstly, the pleading complaint by the ANC is a bad one, because in the founding papers, we made the same allegation that we had made in my client made in the reply. But what happens is this. In the founding affidavit, the allegation is made that President Ramaphosa had misled the Commission. The President files an answer, and in our reply to the answer, we explain why even the answer that he gives as to the notion that he misled is not a true answer. It's a lie. So the argument goes in the replying affidavit. And now there's a complaint, which we find incredible, that we didn't plead our case in the founding affidavit to say that there was a lie. The lie was made out in the founding affidavit. It was expanded in the answering affidavit. And then in the reply, it was pointed out that the understanding of the President and the government as to the nature of the Zondo Commission findings wasn't correct. May I just turn to something while I'm just at this topic? Justice Mojapela asked me yesterday about the question of I think he used the word, and I had a debate with him about the recommendation of the Zondo Commission, and I responded by saying there was a finding, and then the question of recommendation came over. I don't know if the court will recall that interchange that I had with Justice Mojapela. Now what happened, the true fact that happened in this case, was that Justice Zondo made the finding that our learned friend for the Minister repeated this morning and has been at the forefront of the debate, that the taking into consideration of cadre deployee recommendations was unlawful, unconstitutional. The court will recall that. But didn't make a recommendation there too. So it didn't say to the ANC or the President or the government, look, this cadre deployment besigheid is bad, now I want you to get rid of it. It didn't say anything like that. It just laid it bad and said you must develop plans to avoid this kind of difficulty. And what the President says is this, on case line 002518, and we submitted startling that a President of a country can make this submission. He says, on oath, and he's just read certain things, and he says, it is clear from a reading of these paragraphs, this is of the Zondo Commission report, that they do not constitute recommendations from the State Capture Commission, but instead submissions made to the Commission on what should be contained in its recommendations. Ultimately, and this is the key to what the President tells this court, ultimately the State Capture Commission did not recommend that the CD, that's cadre deployment policy, be revoked, or that the nomination and selection of candidates be removed from the control of government ministers. What's the President telling the court? There's a commission established by the President, as our learned friend for the President made the point this morning, pursuant to the Public Protector's report. The commission makes a finding that cadre deployment is unlawful without a recommendation. And the President tells this court, well, not a problem, because there's no recommendation to revoke it. So we'll continue with this unlawful policy. It's effectively what the President tells the court. And the court will consider the 5 aspects that the President and the government put forward this morning, and the Minister put forward, why it is that they so heavily oppose this application without any reference to the policy. Yes, they have a duty, they cite it, and yes, they have a duty to help the court. Help the court with what? How the government understands a particular party's policy, what the government says could happen, should happen, were the court to grant the relief. That started in Darwood. In Darwood, the Minister of Home Affairs opposed the application for confirmation to the Constitutional Court. About a week before the hearing, the Minister withdrew his opposition and withdrew the appeal. It was a counter-appeal. And a Reagan J for the Constitutional Court criticized the government for not assisting the court in what would be just and equitable relief. And what we submit is, yes, we expect the government, we expect the Minister, we expect the President to assist the court in understanding this notion of undermining multi-party democracy. We expect them to do so, but we do not expect them to heavily oppose in the way that they have. Taken interest in one party's policy compared to another, one political party's policy compared to another political party. And one suspects, just speculation, but if it was any other political party that's policy was being challenged, would the government of the day support the opposition? One wonders. If it was the UDM, the EFF, the ACDP, etc., any of those political parties whose policy was being challenged by another political party, by the DA or some other party, would the government of the day seriously have defended that policy? One wonders. With government money, with taxpayers' money? Defending a particular political party's policy with taxpayers' money. And that's the question that we made in our heads of argument. I made the point yesterday. And it's a question that the court will consider. We submit that prayers 1, 2, and 3 ought to fall to be granted with costs as I've submitted against the 3 separate teams opposing the relief sought. And as far as, and those all 3 prayers would fit under the remit of 172(1)(a) of the Constitution. We've heard no submissions in respect of just and equitable or possible just and equitable relief. And the only one that we can assist the court with is to say something along the lines of word up to the, if the court's minded to go in the 172(1)(b) route, which we invite the court to do, any order, is to consider whether to make that order prospective, retrospective, or comes into operation on the date of the order, or otherwise, as it pleases the court. Thank you.
Us in arriving at the proper order. I'm not going to give judgment today, it's obvious, but judgment will be given at our earliest convenience. We are aware that it's an important matter, that the clarity is sought. We're going to postpone this matter and judgment is reserved. Court adjourns.